Welcome back to the Deep Dive. Today we are strapping in for a deep exploration of a legal battle that challenges not just a single marriage, but the entire foundation upon which modern American divorce law rests.
It really does. We are moving way beyond the typical disputes over, alimony or who gets the house.
Right. We're going straight into a constitutional showdown.
Yeah.
Our mission today is focused entirely on a complicated, really high-stakes Oklahoma divorce case, Aikins v. Aikins. It's a case that has made its way all the way to the Oklahoma Supreme Court.
And we've been through the core source materials. The legal briefs from the appellant husband are just meticulously detailed. We also have trial transcripts, expert commentary.
All of it centered on attacking one specific statute, Oklahoma's unilateral no-fault divorce provision. That's Section 43, Tact 1017, the one that allows divorce based on irreconcilable incompatibility.
And what's truly extraordinary here, and really why this case matters far beyond Oklahoma, is the sheer scope of the challenge. The husband, James Alan Aikins, he's the appellant. And he isn't just seeking to, overturn the divorce decree in his specific case.
No, he's going for something much bigger.
Much bigger. He is launching a facial constitutional challenge. He's arguing that the incompatibility statute itself is inherently unconstitutional and should be declared void ab initio.
Okay, let's unpack that legal Latin for a second. Void ab initio. It literally means void from the beginning. Why is that terminology so critical here?
Well, it carries just devastating implications. I mean, if the Oklahoma Supreme Court were to agree that the statute is unconstitutional and void from the start,
then everything built on it crumbles.
Exactly. Legally, any judicial action that relied on that statute is also void and unenforceable. Think of it like a foundation. If the foundation is rotten, every single structure built on it just collapses.
So if this challenge were actually successful, we're not just talking about the Aikins divorce decree being invalidated. We're talking about potentially millions of people across Oklahoma whose lives, their marriages, financial structures, mortgages, and most importantly, their custody arrangements. Everything has been restructured based on a law that a court might later rule never legally existed. The husband's whole point is that if the statute itself is illegitimate, then the trial court in his case,
which was presided over by Honorable Mindy M. Bear.
Right. That court lacked what's called subject matter jurisdiction, the inherent authority to even hear the case, to grant the divorce in the first place.
It's a total reset button, and that's why the legal community is watching. This challenge targets the fundamental structure of no-fault divorce laws that, frankly, most people assumed were settled law decades ago.
It really raises the question, was that entire transition away from fault-based divorce constitutional? Let's start by setting the timeline in the personal context. James Alan Aikins and Rachel Claire Aikins were married in Tulsa on December 30, 2006.
And they have two minor sons who were, I believe, aged 10 and 12 when this all started.
The legal action kicked off on August 21, 2023. The wife filed a petition for divorce.
And she relied exclusively on those no-fault grounds we mentioned, irreconcilable incompatibility. Under that Oklahoma statute, you don't need any proof of fault. All it takes is the unilateral assertion by one person that the marriage can't be saved.
And the husband's opposition was immediate and fierce, both personally and legally. He asserted in the record that, from his point of view, the marriage was not in a state of irreconcilable incompatibility.
And that is the defining conflict right there. One person says the contract is broken, the other says it is not. And the law, as it stands, requires the court to accept the first person's subjective opinion without any evidence.
Which quickly launched the constitutional challenge. The husband, acting pro se, and that's important, it means he was representing himself without a lawyer.
Right.
He filed a motion to dismiss on May 16, 2024. And this motion laid out his whole challenge to the constitutionality of the law under both the U.S. and Oklahoma constitutions. And here is where the procedure gets intensely controversial. This becomes central to the due process claims later on.
It really does. The trial court denied that motion to dismiss incredibly quickly, just 6 days later, on May 22, 2024.
And instead of engaging with these really complex constitutional arguments he was making, the court just dismissed the motion. It labeled it untimely and disingenuous.
And this rapid denial created just a glaring procedural anomaly that the husband seized upon for his appeal. If you look at the court record, the timeline is everything.
Okay, walk us through it.
The husband filed his notice of appeal on May 23, 2024 at 1:02 p.m. But the wife's formal legal response, her objection in response to the motion to dismiss, which had all legal arguments defending the court's jurisdiction.
It was filed later.
It was filed after the court had already issued its denial order and after the husband had already filed his appeal. Specifically, it was filed at 1:19 p.m. on that same day.
Wait, let me make sure I'm getting this straight. The trial court denied a dispositive motion, a motion that argues the court has no authority to proceed without even having the opposing party's legal argument on the record.
Correct.
And then the court's order effectively adopted the legal reasoning that the wife only filed 17 minutes after the husband had already appealed.
Yeah.
I mean, that sounds like the definition of ruling without a complete record.
It is. And the husband argues it suggests a possible ex parte communication. Ex parte just means communication made by one party to the judge without the other party present, which is generally a huge no-no.
For fairness.
Exactly. And even if there wasn't any improper communication, the outcome is the same. The trial court failed to provide a reasoned, analyzed basis for denying a motion of this magnitude, a motion challenging its own jurisdiction. He argues that's a clear breach of due process, and he cites some big Oklahoma Supreme Court cases to back that up.
And on top of that, when you're challenging the court's fundamental authority, that kind of challenge can never really be untimely, can it?
It can't. The Supreme Court has confirmed it again and again. Arguments about subject matter jurisdiction, especially ones claiming a law is void, can be raised at any time, even years later on appeal.
So calling the constitutional challenge untimely was, legally speaking, a procedural error that just dodged the real issue.
It completely avoided the substantive question.
And the whole procedural landscape is even more complicated by the husband's repeated claims that he was forced to act pro se in the first place because he couldn't afford a lawyer.
Right, and he argues that inability came directly from the wife withholding marital assets.
Is there anything in the record to support that?
Oh, yes. The court transcripts confirm this narrative. The husband was served back in October 2023, and he had 20 days to respond. In a hearing in December, he told the court he'd been asking his wife to honor the automatic injunction.
That's the standard temporary restraining order that goes into effect when a divorce is filed, right?
Exactly. He needed her to honor it so he could get the resources to hire a lawyer. He stated in court that his wife had maintained, quote, complete control of all of our assets since December 19th, 2022.
Wow. That's a huge leverage point in any divorce.
Yeah.
If one spouse controls all the money, the other spouse is financially crippled. You can't fight a complex constitutional battle with no resources.
Precisely. And while the trial court did initially show some recognition of this, it refused to grant a default judgment against him just for his delay in responding.
So it gave him some leeway.
It did. But the eventual denial of his constitutional motions still proceeded without the benefit of legal argument from a trained attorney on his side. So the core argument is that the wife's control over the assets created an environment that just severely hampered his due process right to defend his civil status.
Now we have to move from the dry language of procedure to the intensely fraught personal narrative, which really provides the emotional backdrop for why the wife sought the divorce and why the husband is fighting it so hard.
Right. And the wife's answer brief does not mince words. She claims she endured mental and physical abuse during the marriage. She asserts this led directly to their children developing severe behavioral issues that required extensive therapy.
So she's immediately establishing a narrative of fear and protection.
Absolutely. And the context she gives for the separation is, well, it's dramatic. Her brief says the marriage fractured after what she called a nightmare trip to Canada.
What happened on this trip?
During the trip, while they were in Colorado, the husband was detained by police after exhibiting some really erratic behavior. He was allegedly seeking political asylum and claiming that the Pittsburgh County Sheriff's Office and even Governor Stitt were trying to get secrets he had.
So she's using this sequence of events to frame the husband as an abuser and the divorce as a necessary escape.
That's the frame. But this is where the medical counter-narrative becomes absolutely essential to understanding his side.
Okay, what is his counter-narrative?
In preparation for the custody part of the case, the husband gave the guardian ad litem a lot of medical documentation. He argues the case is based on unsubstantiated claims, not actual evidence of abuse.
And the erratic behavior.
He contends it wasn't willful abuse or malice, but a documented medical crisis serotonin syndrome.
Serotonin syndrome. That's a serious condition, right? It's usually caused by drug interactions that lead to way too much serotonin activity in your brain.
It's extremely serious, and the husband claims this entire episode, including that bizarre behavior in Colorado in December 2022, was caused by a dangerous combination of prescription pain medication.
For what?
For a tooth extraction he had had in October 2022. So that pain medication, combined with his daily anxiety and depression medication, sertraline, which is a common SSRI.
And the wife's own testimony stated she was also taking sertraline, so you'd think there would be an awareness of the sensitivity of this kind of medication.
You would think so. The combination of an opiate painkiller and an SSRI is known to be able to trigger this syndrome.
And the immediate aftermath of that incident just compounded the crisis, didn't it?
Oh, absolutely. He was taken into custody in Colorado, and he claims he was initially misdiagnosed with paranoid schizophrenia. He was placed on an M1 hold and given powerful antipsychotic drugs.
Which he argues were completely wrong for him.
He argues they severely contradicted his known medical profile, including pre-existing sleep apnea and ECG issues. He says they potentially put his life in danger.
The diagnosis trail after that, it shows a pretty clear picture of complex mental health issues, moving far away from that initial misdiagnosis.
It does. By early 2023, the formal diagnoses he received included general anxiety disorder, major depressive disorder, and PTSD. Later that summer, he was diagnosed with betrayal trauma.
So his argument is that this sequence, a medication interaction leading to a psychiatric crisis, followed by a misdiagnosis and trauma, that explains the behavior the wife called abuse. But it doesn't indicate malicious intent or actual spousal battery.
That's his entire point. And crucially, he also challenges her narrative about the children's issues. The wife claimed their severe behavioral issues were caused by the unhealthy marriage.
But what does the evidence say?
The husband contends the children's medical, mental health, and behavioral issues were all pre-existing. He notes that both sons had been in speech therapy, and the older son's anxiety and curriculum needs. They predated the separation and even the family's move to Oklahoma.
So the core of his factual counterargument is that this whole divorce is based on the wife's subjective and really unsubstantiated claims about incompatibility and his alleged poor parenting or abuse.
Exactly.
Let's underscore that vital point. Based on the court documents we've seen, was any evidence, any testimony, any corroboration ever presented in court by the petitioner, her attorney, or the guardian ad litem, that's Mrs. Ellen Quinton, to confirm any kind of physical or mental abuse?
No. According to the court records and the source material, there was zero evidence and no witnesses presented in court to substantiate any of the claims of abuse that form the background narrative.
So the case just proceeded strictly on the legal grounds of incompatibility.
Purely on the subjective opinion of the petitioner. The husband actually tried to subpoena witnesses about his medical crisis, but he was denied a continuance in May 2024.
This lack of substantiation makes the custody and separation issue all the more tragic. What was the original understanding about the separation, and what's the reality now?
The husband asserts the separation was supposed to be temporary. They're both Catholic, so it was supposed to align with canon law until he was medically and mentally cleared and they could start reunification therapy.
But the reality is far from temporary. The sources paint a really stark picture.
They do. The husband was the primary stay-at-home father from June 2016 all the way until that separation in December 2022.
And
yet, according to his filings, he has not spoken to or seen his two sons since December 2022.
Let me process that. As of the filings in late 2025, that's over to 1070 days.
Over 10 and 70 days of complete separation from his children.
That's over 3 years without contact after being the primary caregiver. That transition from daily father to basically an absent stranger. That's just brutal.
It is the devastating consequence of the power dynamic created by the unilateral divorce and the allegations. He alleges the wife has engaged in severe parental alienation, refusing to give him medical or school records, blocking all contact, and effectively telling him his only remaining obligation is child support.
And this tragic reality forces us to confront this systemic critique in the source material. This concept of the silver bullet in divorce litigation.
Right. The silver bullet concept describes a legal strategy. It's the calculated use of false or, unsubstantiated allegations of serious abuse, often sexual abuse or physical violence, to gain an immediate and overwhelming tactical advantage in custody proceedings.
And the article we have highlights why this strategy is so effective, whether it's true or not.
It's effective because it works immediately. Claims like that often result in immediate temporary protective orders. They force the targeted parent out of the house and sever their access to the children, all without needing corroborating evidence or due process in that initial critical phase.
The ultimate success of the silver bullet doesn't depend on the truth coming out later, does it?
Not at all. The advantage you gain in that moment, immediate custody, physical separation, is often irrevocable. Even if the allegations are later proven false, that parent has already lost months, maybe years, with their children, and they're trapped in a financially ruinous fight.
The source also dives into the inconvenient gender symmetry statistics, which provide some really essential context here.
They do. While data clearly shows men cause greater injury and intimate partner violence, other data suggests women are statistically as likely or even more likely to initiate violence in relationships.
But that symmetry starkly contrasts with the custody realities.
Oh, completely. Mothers get custody in at least 82.5% of cases nationally. Fathers pay over 85% of child support. And this disparity persists even as gender roles in work and education have become more equal.
So critics argue that this system, which seems designed to protect mothers, inadvertently creates an environment where a strategic, unsubstantiated claim, a silver bullet, becomes the most powerful weapon you can deploy to ensure a favorable outcome, regardless of the facts.
And for the husband in this case, that's the devastating personal cost of a law that demands no proof of fault or objective incompatibility.
The personal stakes are clearly immense, but now we have to transition to the heavy legal challenge that's trying to dismantle the very system that allowed this to happen. Proposition I targets the heart of the matter, the contract clause of the U.S. Constitution.
And this is where the challenge moves from family court drama to high-level constitutional law. The husband argues that Oklahoma's unilateral no-fault statute, it violates the contract clause by dissolving the obligations of the marriage without either a legal default, meaning fault, or mutual assent.
But the standard legal understanding, going back to the 19th century, is that marriage is not just a private contract. It's a civic institution regulated by the state's police powers. How does he get around that huge hurdle of precedent?
He acknowledges that precedent. He knows about cases like Maynard v. Hill from 1888, which established that marriage is a public institution subject to the state's authority. But, and this is the key, he argues that the unilateral no-fault statute fundamentally abuses or exceeds that police power.
And in doing so, it puts the marriage back under the protection of the federal contract clause.
That's the argument.
This brings us to some legal archaeology. To launch a modern constitutional challenge against the 20th century law, the husband reaches back over 200 years to a landmark case, Dartmouth College v. Woodward from 1819. Why is this case the linchpin?
Well, Dartmouth is famous for protecting corporate charters under the contract clause, but within that ruling, the court also had to address the nature of marriage. The opinion recognized marriage as a civil contract governed by state law, but critically, it outlines specific constitutional limits on what a legislature could do.
And what are those specific limits? These must be the so-called Dartmouth exceptions?
Exactly. Dartmouth laid out two specific scenarios where the federal contract clause must apply to restrict state divorce laws. The first one is a hypothetical total abolition, when any state legislature shall pass an act annulling all marriage contracts.
Okay, and the second one, the one the husband claims is exactly what's happening in Oklahoma.
The second exception prohibits the state from passing a law allowing either party to annul it without the consent of the other. The husband's argument is that Oklahoma's unilateral no-fault statute does precisely this. It lets one party terminate the marriage contract based purely on their subjective opinion without needing the other's consent or proof of a legal breach.
That distinction is incredibly important. In a traditional fault-based divorce, say for adultery or cruelty, the state isn't just annulling the contract randomly, it's dissolving it because one party broke the contract.
Right. There's a legal breach, and the contract clause doesn't traditionally protect a party who is in default.
So that's the constitutional gap he's exploiting. He's saying that when Maynard v. Hill and other cases affirmed the state's power over marriage, they were operating entirely within a fault-based system.
Completely. In that system, the Dartmouth exception about annulment without consent was never an issue, because dissolution was always justified by a proven breach of duty, which is fault.
But with unilateral no fault, the state is dissolving a contract without a breach and without consent.
And this, he argues, places the statute squarely within that unadjudicated second Dartmouth exception, which makes it a violation of the federal contract clause.
So his whole argument is that the precedents that uphold state authority over marriage, like Maynard v. Hill, they only apply to fault-based divorce.
Yeah.
Because unilateral no fault didn't exist when those cases were decided, the precise question of whether the contract clause protects against termination without fault or consent, it's never been properly adjudicated.
That is the central legal question of the entire case. Does the state's police power to regulate marriage go so far as to allow one party to unilaterally void the civil status of the other with no legal default? He argues the contract clause places a clear historical barrier against it.
This connects directly to his secondary argument within Proposition 1, the claim that Oklahoma has effectively abdicated its police power through this statute. What does he mean by abdication?
Well, the state's police power is its right to regulate for public health, safety, and welfare. Marriage is regulated because it serves a public interest, stable families, raising children, that sort of thing.
Okay.
The husband contends that these incompatibility grounds are just a procedural trigger for dissolution. They don't regulate conduct or maintain the institution of marriage. They just endorse one party's private desire to leave.
So if the state is supposed to be the guardian of this public institution, but its law just rubber stamps a private whim, then the state isn't really exercising its police power in a meaningful way.
Precisely. By getting rid of the need for proof of a breach, the state is basically delegating its legislative authority, the power to terminate a civil status, to the petitioner. And when the state abdicates its role like that, the husband argues he's entitled to invoke the protection of the federal Constitution.
The counter-arguments from the wife's side and the Court of Civil Appeals, they naturally rejected this, right? They cited cases that affirm the state's right to set divorce grounds.
They did. That's the standard defense. Divorce is statutory, the state sets the rules. They cite cases that say marriage isn't a contract for the purposes of the contract clause.
But the husband's reply is that those arguments miss the point. They fail to address the specific historical constitutional limit laid out in the Dartmouth exception.
Exactly. His strategy is highly surgical. He isn't fighting the state's general power to regulate marriage. He is fighting its power to legislate in a way that falls into one of the only two exceptions where the contract clause was ever said to apply.
He's basically arguing for the preservation of marriage as an enforceable legal bond, one that's protected by the U.S. Constitution from laws that turn it into a legal fiction.
That's what it all boils down to.
Moving on to Proposition 2, we get into even more unusual constitutional territory. The husband challenges the no-fault statute under the First Amendment speech clause, claiming it violates the ban on viewpoint discrimination.
I have to say, that's not an argument you typically hear in family court.
No, it's a truly ambitious legal maneuver. The whole argument hinges on the distinction between regulating actions, which the state can do, and regulating opinions or beliefs, which get absolute protection under the First Amendment.
Okay, so how does that apply here?
He argues that the statute regulates viewpoint because the grounds for divorce incompatibility rely entirely on the petitioner's unilateral, subjective assertion of a belief, the belief that the marriage is broken.
So we need to clearly define the difference between regulating conduct and regulating opinion in this context. Right. When the government regulates conduct, it regulates a demonstrable action. Think of the state regulating polygamy. That's regulating an action. The state can regulate the action, but the state cannot regulate the belief itself.
And in a fault-based divorce, the state regulates the conduct. Adultery, abuse, abandonment, these are tangible breaches of duty. How is incompatibility different?
Incompatibility, by definition, is a subjective state of mind. It's an opinion. The husband argues that the statute fails to establish a proper cause of action. A cause of action needs objective elements: a right, a duty, a breach of that duty, and a remedy.
And when a petitioner just says, I believe we're incompatible, they're not demonstrating a breach of duty.
They're asserting a belief. And since the statute gets rid of the need to prove a breach, the conduct, it fails to regulate behavior. It only regulates and enforces a subjective opinion.
So if the law is regulating a subjective belief, how does that become illegal viewpoint discrimination?
Because the state compels the court to accept the petitioner's belief as definitive, the statute effectively adopts and endorses the petitioner's message: this marriage is incompatible.
And at the same time, it makes the respondent's opposing viewpoint, I believe the marriage is compatible and salvageable, legally meaningless.
That's the discrimination. The state isn't just listening to both sides, it's legally mandating that one opinion is true and the other is false, without any objective criteria. The government uses its coercive power to promote one ideological belief about the marriage while actively discriminating against the other.
And because it's a content-based regulation, it triggers the highest level of judicial review, strict constitutional scrutiny.
Which is notoriously difficult for the government to meet. The husband argues that there's no way it can. The state isn't just regulating conduct incidental to expression, it is legislator based on the content of the belief itself. He says the statute forces the court to act as a mere conduit for one party's belief, which is a violation of the separation of powers.
This discrimination claim relies heavily on the fact that the respondent has no legal recourse. Let's talk about the impossibility of mounting a defense under this statute.
Numerous state court decisions have confirmed this reality. Cases have established that the respondent in a unilateral no-fault divorce cannot successfully challenge the petitioner's assertion of incompatibility. They can't introduce evidence to prove the marriage is actually compatible.
So, if the husband had walked into court with 20 marriage counselors ready to testify that the marriage was salvageable, their testimony would be irrelevant.
Legally irrelevant. The judge is compelled by the statute to accept the petitioner's opinion as the sufficient legal basis for divorce. It eliminates all traditional defenses.
And he argues this confirms that the statute isn't regulating conduct, but rather compelling judicial endorsement of a private, ideological viewpoint.
In summary, Proposition 2 asserts that unilateral no-fault divorce operates outside the traditional boundaries of law regulating belief instead of conduct, and thereby violates the First Amendment by discriminating against the respondent's viewpoint on the marriage.
We've covered some incredibly dense constitutional law. So what does this all mean for the human beings involved? The husband's entire challenge, no matter the legal theory, is driven by the very real consequences of having his civil status altered without his consent or any fault on his part.
The consequences are profound. His legal filings detail the immediate effects. Beyond losing the marriage itself, the change in his civil status immediately impacts over 11,138 distinct federal benefits, not to mention countless state benefits. It just drastically alters his financial and administrative life.
The most immediate one is probably tax status, right? Moving from married filing jointly to single almost always means a bigger tax bill.
For sure. But the most crucial impact, especially given everything we discussed earlier, is the loss of his civil right to parent. As we noted, he has been separated from his sons for over 170 days.
The change in marital status dictates custody and access, which he argues was already severely diminished based on those unsubstantiated claims and a system that didn't allow him a meaningful defense. We touched on the role of the guardian ad litem, or GAL, Mrs. Ellen Quinton, earlier. In these highly contested custody cases, the GAL is supposed to be the eyes and ears of the court. How does the system view their function, and what tension arose here?
The GAL's role, according to their own manual, is to objectively advocate for the child's best interests. They're supposed to be impartial investigators. Crucially, they are mandated to investigate allegations of abuse. However, the manual advises them to rely on reports from trained experts like DHS or the police before doing their own investigation if serious abuse is suspected.
Which just reinforces the husband's point from earlier. If the wife is alleging abuse to justify the separation, why did the case proceed without any official corroboration from trained experts or any evidence presented in court?
It suggests the court relied more on the subjective narrative in the pleadings, the incompatibility claim, than on objective findings of fact about conduct. The no-fault mechanism allows the court to sideline the need for factual proof of abuse and just focus on getting the dissolution decree done.
There was also a concern about the confidentiality of his medical history that he provided to the GAL.
Yes. The husband was worried because he was also thinking about a medical malpractice case related to the serotonin syndrome misdiagnosis. The GAL manual says their reports are filed under seal and generally aren't discoverable. But Mrs. Quinton confirmed in the transcript that while the final report is sealed, the communications leading up to it are not confidential. He was hesitant to provide highly sensitive medical information if it could be used publicly against him later, which just highlights the lack of trust created by the whole adversarial process.
The husband's filing elevates this personal grievance into a really grand critique of the system itself. What's his ultimate conclusion about what these incompatibility grounds have done to the institution of marriage in Oklahoma?
He argues that the incompatibility grounds have devolved into a cold, arbitrary, and unilateral application, which has rendered marriage unenforceable as a legal institution. His argument is powerfully simple. If one party can dissolve the contract for any reason or no reason at all, without consequence or proof default, then the marriage stopped being a genuine legal contract and just became an illusory promise.
Which leads to his provocative claim. If the legislature insists on using these grounds, they might as well abolish marriage as a civil institution entirely. Why abolish it instead of just reforming it?
Because, in his view, the current statute has already reduced marriage to nothing more than a dating scheme terminable at will. By keeping the name marriage but stripping away all the legal enforcement mechanisms, fault, defense, mutual assent, the legislature is creating a fraudulent institution.
The ultimate context for this legal despair is brought home by those statistics we mentioned about the high stakes of adversarial divorce, especially for fathers.
The source material is brutally honest here. The staggering statistic that American fathers caught in the divorce system kill themselves 8 times more frequently than mothers who do. It just speaks volumes about the level of despair felt by many who face a system critics see as adversarial and profoundly biased.
So the husband's constitutional challenge isn't just a technical legal fight. It's a profound, desperate attempt to use the highest legal principles to restore accountability and due process to a system he feels has already predetermined his outcome, based solely on the subjective, unchallengeable opinion of the petitioner, amplified by unsubstantiated allegations.
He is fighting for the legitimacy of the contract itself. He is fighting to prove that the state legislature, when it created unilateral no-fault laws, exceeded its constitutional authority by ignoring a clear historical limitation that was established all the way back in 1819.
So this deep dive has explored the full scope of Aikins v. Aikins, a pro-se constitutional battle against the very foundation of unilateral no-fault divorce. We went from the tragic personal context, unproven allegations versus a documented medical crisis, leading to over 1070 days of parental separation, to the heavy legal artillery targeting the contract clause and the First Amendment.
And we really dissected the critical importance of the Dartmouth exception and the argument that unilateral incompatibility is a form of illegal viewpoint discrimination.
The core takeaway here is this. The challenge isn't really about the desirability of divorce itself.
No, not at all. It's about the constitutional legitimacy of the state to forcibly rewrite a person's civil identity and status, stripping away legal rights and access to his children based solely on the unchallengeable assertion of incompatibility by one party, all without any requirement for fault, mutual consent, or any evidence presented in court to support the allegations that fueled the separation. The husband is arguing that if there is no breach of duty, the state has no constitutional right to intervene and dissolve the bond.
And that leads us to a final provocative thought for you to consider. If the state, through statutes like this one, has indeed abdicated its police power by failing to enforce or regulate the marital contract, what responsibility does that leave the individual citizen?
Right.
If the state reduces the marriage contract to a temporary, terminable at-will arrangement, does it still deserve the legal protections and public status of a civil institution? Or has the legislature inadvertently created a situation where the only way to protect your rights is to invoke federal constitutional principles established centuries ago to protect against this very kind of legislative overreach? Thank you for joining us for this deep dive into the complex intersection of family rights and constitutional law. We'll see you next time.